What Church of Scientology is so afraid of.
This is SPTV.
Welcome back, everybody, for more SPTV coverage of the Danny Masterson trial live from Los Angeles. I'm joined today by my attorney friend, Zach Morgan. How's it going?
I'm good, Aaron, and welcome to all of your viewers. I know that we've been doing sort of a play-by-play, and then life got in the way, and you were traveling across the country, and then the last couple of witnesses with the police officers wasn't a whole lot I could contribute to that. It was sort of the fact witnesses were the fascinating part of the trial.
Yeah, it's crazy. We even had a plan to do like a post day analysis every single day of the trial, and it just totally fell apart. But yeah, so let's see some things that we wanted to discuss. I'll tell you some of the questions that have come up just very recently are in a trial like this, in a case like this, with a defendant like this, with charges like this, if he's found guilty, should we expect him to be taken into custody right from the courtroom, or does he get to chill out and get his affairs in order while he awaits sentencing?
So the short answer is I fully expect that if the jury returns a jury verdict of guilty, the jury will be thanked and dismissed. And then the next thing out of the judge's mouth will be the defendant will be remanded into the custody of the LA County Sheriff and held at the LA County Jail pending sentencing. And at that point, they will then have, set a date for sentencing and any pre-sentence reports or anything. I think where that question comes from is like Elizabeth Holmes, the Theranos lady. She was, and you see it all the time, high profile criminal cases in the federal court system. Oh, he was guilty and he has to report by June 1st to get his affairs squared away. That's broad latitude given to federal court judges. Most state court systems either don't allow that or don't account for that because the federal government has a whole lot more resources to keep this person from fleeing the country or trying to go to a non-extraditable country. State governments generally don't have near the resources. They don't have the U.S. Marshals and the FBI to go track these people down around the globe. So most of the time on a guilty verdict, you're immediately going to go sit in the county jail pending sentencing.
That makes sense. And what about the subject of appeal? If Danny wants to appeal, if his team appeals, is it the same thing? Like, if it was a federal case and he wanted to appeal it, the question is basically, is he going to be able to be out of sentencing pending appeal? No. It sounds like no.
No, because if you see all the time, somebody was convicted of murder 30 years ago, they spent 30 years in prison, and then on appeal, their sentence was reversed and they opened the jail cell, but they still sat in prison for 30 years.
Right. I guess in my mind, I always thought that that's because they didn't choose to appeal until they were already in prison. But maybe if they appealed right away, if they had more better. But no, that's you do not get to stay out of prison while you're on appeal, pretty much no matter what.
For a couple of reasons. One, the same thing I mentioned earlier, but two, the appellate process. First off, everybody has a first right of appeal. So even if I get first, I can almost bet all the dollars in my pocket that he will appeal the verdict if it is a guilty verdict, that he being Danny Masterson. Secondly, and I don't want to say more importantly, but secondly, you generally have a very finite period of time. Some states it's 8 days or 10 days. Some states it's 30 days to file what's called the notice of intent to appeal. And that puts the court on notice, start gathering all of the transcripts and records from trial, preserve it all. And then there's a different deadline, generally months down the road, in which you get a briefing schedule from the appellate court to court of appeals or whatever, however the court system is structured in that state. The briefing can take 60 to 90 days. And then after the court is submitted to the court of appeals to review, it can often take months because after the case is briefed, the judges will take argument, if any, oral argument. They will deliberate about it in a conference room, reach a decision, and then it takes months to circulate the draft opinion around till all the judges on the appellate panel agree or disagree and write a dissent to the majority opinion. So it can take 8, 9, 10, 12, 13, 15 months at the intermediate appeal level. And stuff that goes all the way to the United States Supreme Court can take a decade or longer to have an order from the U.S. Supreme Court if they decide to accept it on a writ of certiorari.
Interesting. So, well, for those out there who may have the same questions I do, you can't just appeal on the basis of we disagree with the verdict. I'm assuming there has to be, you have to claim that there was some fundamental, what's the legal term? Something wrong with the procedure, something that was screwed up. What's the legal term?
Reversible error. So there's two types of errors. The judge sustained an objection that she shouldn't have, or maybe the judge overruled an objection she should have sustained. And the court would say, yes, the judge got this wrong, but there was so much other evidence that it's not reversible. We call that harmless error. But if the judge read a wrong jury instruction, let a witness testify that she shouldn't have, improper argument, or got a piece of law wrong, hey, I'm going to apply law A to the case. The appellate court says, no, it's law B. That's called reversible error. But you could, so what'll happen procedurally if there is a verdict of guilty, after the jury retires, the defense will ask for what's called a JNOV, a judgment notwithstanding the verdict. Judge, even though the jury returned a verdict of guilty, the evidence is so overwhelming that our client didn't do this. The jury clearly got it wrong, and you should therefore acquit the defendant regardless of the jury's verdict. That's super routine. It's kind of like saying, I want a mistrial because today ends in Y and it's windy. Right? Super routine, almost always overruled. No, I'm going to deny the motion. We're going to move on. But they've made the appeal. They've made the record for the appeal. And then when you appeal, you list everything that you think the judge got wrong. Should have granted the JNOV, shouldn't have allowed this testimony, should have granted this, should have sustained this motion, this objection, should have granted this motion, whatever. And so then you list all of the grounds for appeal, and the appellate court sorts through those. They will address them all. They may say, well, we've resolved issue 1, so the other 3 don't need addressing. Or they may say, we can dispose of issue number 1. Yeah, that doesn't apply here. The judge got it right, and move on. So they can spend as much or as little time discussing that in the opinion as they want to. That's the purview of the appellate court.
I must imagine, correct me if I'm wrong, that as a judge, one of the things you're trying to avoid professionally is being overturned on appeal. Is that accurate?
It is. And so there's a trick. Lawyers will, well, judge, we think that's reversible error. And the judge says, okay, take me up on appeal. It's part of the job. The judges want to get everything right. And it's not so much that they're scared of getting reversed. Some of the most famous cases in history resulted as reversals of the lower courts. It's not so much that they don't want to get reversed. It's that they want to get it right for the sake of justice.
Sure.
They don't want to get the law wrong.
Is it professionally embarrassing to be reversed as a judge?
Unless it's something like abuse of discretion, where the judge just went rogue and decided that he or she was going to be the king of England for a day. Generally not. It happens. If you sit the bench long enough, you're going to get reversed. It's just going to happen. So,
you know, the question occurred to me because when you have, what is it, certain judges going through like the Senate confirmation process, is that maybe for the federal courts? I always wondered if part of their professional resume, when being considered for a lifetime appointment on whatever,
sure.
If it's, you know, I'm batting 1,000%, I've never been overturned on appeal. Does that come into play at all?
A little bit, but also remember that judges are bound by the law that exists at the time. And if on review, the court says this law is not constitutional or this law is wrong, we have to throw this law out. The judge didn't get it wrong. The judge followed the law. The appellate court decided the law was bad. And in that case, the judge didn't do anything wrong. The court said the law was bad. You followed the law, but it was bad law. We're going to fix it.
Right.
And the only
reason I'm even asking all these questions is because it did occur to me while I was just watching the proceedings that perhaps one of the reasons why Judge Almeida is so deliberate and careful and patient and calm and thorough in reading all the statutes and earlier decisions that she's using to support her decisions, other than just being good form and being professional, it occurred to me, this is what judges do so they can never be overturned on appeal. They're very meticulous and methodical and thorough. And it just occurred to me if there was a self-preservation aspect of that, is like, I don't want to get overturned.
Yeah, I think there's a little bit of a self-preservation aspect of it, but I think also the judge's duty is to do that research and have that law ready. Like, hey, and that's why you've seen it probably. Hey, judge, tomorrow morning we have some issues we need to take up. Well, what do we need to address? Well, we need to address such and such as witness's testimony. Well, so the judge that night's going to go do her homework. She's going to come armed with the statutes and the case law that she thinks is relevant. So then she's already up to speed on the law. So when the lawyers make their argument, she's ready to say yes or no.
Yeah. That makes sense. Okay, so we covered the timeline regarding sentencing, regarding appeal. Let me ask you a bit about, this has to do with the rebuttal closing. So the DA gets to do a closing, the defense gets to do their closing, and then the DA gets to do a rebuttal to the defense's closing. Mueller spent a lot of time in his rebuttal, Deputy DA Mueller, talking about the fact that Danny Masterson's victims were drugged and driving home all of the circumstantial evidence that leads towards drugging. Cohen stood up after the jury was dismissed and said, "Your Honor, I do declare." He said he made a big deal about how inappropriate he thought it was for Mueller to focus on drugging when drugging actually has nothing to do with the charged crimes in this case. The crime in the state of California, Danny Masterson is charged with 3 counts of forcible rape. Cohen argued drugging someone and raping them is not forcible rape. If that's what occurred, we wouldn't even be here because the statute of limitations would already be expired. And he said, you know, Your Honor, it seems like it's almost reverse jury nullification. What are your thoughts on Cohen complaining about Mueller talking about the drugging?
So Mueller was talking about the drugging because it's the predicate act that goes to the consent or lack thereof of the Jane Does. Okay. The concept of jury nullification says that a jury can look at a law, can look at the jury instructions, which is the law that the judge gives them, says, I know what the law says, but I think the law is wrong, or I think what you did should be accepted from the law, and we're going to find you not guilty regardless of the evidence. Okay. So the concept of reverse jury nullification, while a big fancy $10 word, isn't a thing. So he calls it reverse jury nullification. I call it the state proving their case. But he uses these fancy terms to sort of implant in the jury. Well, you know, because we've all heard of jury nullification, but if I poll, 100 random people at the local shopping mall and say,
the jury wasn't there when Cohen was,
okay.
So the jury had been dismissed, but this is what makes it almost funnier. It's what Cohen was arguing to the judge.
Yeah. I've never heard that argument. It's not a winning argument. And the judge was probably rolling her eyes up mentally saying, here we go again. How jury reverse nullification? You're going to have to explain that one to me, counsel. That's a new one.
Yeah, it is funny. Cohen seemed to be almost acknowledging that he was making up a word and instead trying to describe a concept. But I just don't know what to think about a professional defense attorney up there making an argument about a legal concept he knows doesn't exist. It just seems to me like, what in the hell? I don't get it.
It may not exist, but remember, Aaron, every legal theory and legal concept never existed at some point. Somebody somewhere came along and invented it.
Mm.
It doesn't mean that he's going to invent it. It's still not a thing, and I can't imagine anybody would jump on that particular wagon. But somebody somewhere at some point tried something for the first time and it worked. And if this is the straw he has a ethical obligation to his client to try and grasp at that straw, regardless of how successful he's likely to be or not.
Got it. That makes sense. That makes sense. All right, let's jump over to some super chats here. Carol just saying says, if Danny Masterson is convicted, losing all appeals and put in prison, will he be allowed to be in attendance at the civil trial? Oh, that's a really good question.
It's actually simpler than it seems. Whether he's convicted or not, he will absolutely be subpoenaed to give deposition and trial testimony at the civil trial, because regardless of whether he's acquitted or convicted, he can no longer assert the Fifth Amendment protection against, as it pertains to these Jane Does, because even if he admits that he did it, the state can't retry him.
Right. So I guess I think
will be subpoenaed.
So I think the emphasis on the question here is, will the prison system allow him to leave prison to attend the civil trial?
So it's not up to the prison system. If he is served with a subpoena, the prison system has to accommodate that. A subpoena is a court order to show up and do a thing, whether it's bring a document or provide testimony. It is a court order to show up, and he will easily be found. You look him up as inmate number, find the facility he's at, serve the subpoena on the warden. The warden walks it down the hall and says, Mr. Masterson, get in the van. We're going to court.
Oh, I got it. So it's even more likely he's going to show up if he's in the custody of the state.
Yeah, because he can't hide. We know where he is. He's in cell 6.
And then ironically, it'd probably be a welcome vacation for him to get out of prison for a bit. And although I guess hanging out in a courtroom is not that much of a vacation, but Interesting. I never thought about that.
And if
Okay.
so, the way that would work in California is a big state. So if he's, you know, having to give testimony in Southern California and LA, but he's being incarcerated way up north somewhere, what they would do is they would actually house him in the local county jail until those legal proceedings were concluded, and then put him back in state prison.
I see. Is there any rhyme or reason to which prison someone gets sent to within the state of California?
That there probably is a policy on that. I don't know what it is. Each state handles it differently. California is a large state, so I know a lot of their prison population allocation has to do with vicinity to where the crime was committed, the type of crime, whether or not there's gang affiliation, you know, things like that. So there probably, I guarantee you there's a policy somewhere. I don't know what it is, but the prison system's job is to keep those inmates safe. So they're going to develop policies that, for example, aren't going to put rival gangs in the same general population unit on the same yard.
Interesting. So something like this where there's no gang affiliation or anything like that.
Yeah.
Would you expect the state to make some sort of an allowance for him to specifically put him somewhere close to where his family live? So they can visit?
You know, I don't know. Possibly. I don't suspect he would be in a maximum security, like a, you know, San Quentin kind of place, because although these are violent crimes, it wasn't murder. It wasn't gangland shootings. It wasn't, you know, violent drug deals or anything like that. Just the nature of the crime, although an awful crime, and he's also not an escape risk. It's not like he's, you know, he's got a bunch of gang buddies in prison who were boring a tunnel under the bathroom floor kind of deal for him. So I don't suspect he would end up in a maximum security prison, although he could end up, some places call it the, solitary confinement or administrative segregation or protective custody, because of, one, the nature of his crime, and two, the fact that he is a high profile inmate, relatively speaking, to the average Joe Blow who's sitting in prison for something. He might spend a lot more time in solitary confinement than he otherwise would for his own protection.
Interesting.
High profile inmates tend to spend a lot of time in isolation.
That kind of sucks, huh? I guess it depends. It seems to me like it would suck. The whole thing sucks, but solitary. Okay, Joshua Cox wants to know, Zach, what type of law do you practice?
So I'm allowed to practice anything I want to. Oklahoma does not recognize legal specialization. You could practice any type of law allowed. My background is primarily in civil litigation, primarily in first-party insurance litigation, so suing insurance companies on behalf of their insureds for failure to provide a covered benefit. But I also do a fair bit of family law, child support, guardianships, divorces, separations, things like that. And then I do some wills, trust, estate plans, end of life planning, things like that. But the large bulk of my practice has been in litigation, both suing insurance companies and representing pilots and other airmen in certificate actions brought by the FAA or other governmental agencies.
Very cool. Calico 26. Were the Jane Does in court today? No, not today. They were Jane Doe 1 was in court yesterday. Jane Doe 2 had already said she couldn't make it. And actually, my understanding is that there was perhaps some concern about all the Jane Does being seen together by the jury, considering the defense would like the jury to believe they've all colluded to get their stories as similar as possible. So, none of them were in court today. They knew that there was only about 30 minutes left of closing arguments, and there was no point really coming in. Let's see. Care for JC YouTube, I think, YT. I may have missed it, but don't they have to find that 2 are guilty or he gets off? I do believe that is the case. They do have to find him guilty on at least 2 counts. And I actually have not heard that mentioned in the jury instructions. And I think
it won't be.
Right.
Because the jury will adjudicate each of these cases, will resolve each of these cases independently on their own individual facts and merits. If the jury knows you have to bat 2 for 3 in order to actually put him in prison, it leads to undue influence and possibly improper negotiation amongst the jury trying to come to a conclusion. Each case, in the interest of justice, should be adjudicated on its own merits based on the believability of the testimony of the witnesses and the arguments of counsel. So the jury will not be notified that they have to get 2 for 3 to lock him up.
Right. And interestingly enough, that means if they, for whatever reason, are able to come to a unanimous guilty verdict on 2 of the charges, and for some reason are hung up on the 3rd, he still goes to prison, right?
That's correct.
Yeah. Very interesting, but remarkable. I know surprising for many to hear that if he only gets found unanimously guilty on one count, he actually doesn't go to prison. Pretty wild. All right. Dave Owens says, I don't believe it until Zach says it. Great stuff. Okay, let's see. How do you say this one? Jen Sisick. Thank you, Aaron and Zach. Looking forward to you starting your channel, Zach. Yes, what's the update on that?
So after looking at the comments and listening to the or following along in the chat, the voice of the majority has won. The name of it will be Your Attorney Friend Zach Morgan by popular demand.
Oh my God, that's great.
So I'm in the process. I'm hoping here in the next week or 10 days, I'll have everything finished that I need to actually take that channel active. And so we'll start doing some joint streaming and sending some of this over to my channel, hopefully the next week or 10 days. So we're just about there. I know you guys have been begging. We're almost there. I promise.
That is going to be so much fun. Oh my God, I love it. All right. Tamara says he is guilty AF. Thanks for the updates, Aaron. Thanks for your input, Zach. Yes, indeed. Okay, on Hada PTS Type D, any news on the Stan assault charge? So I think you mean stand. It is the Stand League, like standing up. The Stand League. Zach, did you hear? Did you know? Did you hear what I said? That what this comment is referring to? Do you know what this is talking about?
I'm not sure I do. You'll have to brief me on that.
Okay, so in the letter that Scientology had one of these fake religious organizations send a letter to the superior or the supervising judge of the courthouse.
Right, the presiding judge.
The presiding judge. And basically complain about Judge Almeida. But in the letter, and it's funny because it's a third-person complaint. The letter was not written by Skippy, and the letter wasn't written by Eva Mahoney, the Stand League journalist. The letter was written by fake Bishop L.J. Gilroy.
Right, I did see all that.
And he claimed that in the letter, Bishop Guillory, who wasn't there, claims that I assaulted the Stand League journalist. Now, if assault can mean verbally yelling at someone, then at least I figured they could justify it. But then the letter claims that the journalist filed a police report against me for the assault. Now, I've never been informed of a police report. Can you file a police report against someone for I didn't yell at her, but can you file a police report at someone for yelling at you?
I can file a police report because my neighbor painted his fence an ugly color.
Oh, okay.
It doesn't mean they're going to do anything about it. It just means a report was taken and it's in a file somewhere. So what?
Oh, okay. So the report literally could be this man yelled at me in a hallway of a courtroom. It literally could just say, but why would a police officer look, I tried to get the police to literally take a report of me being physically and violently assaulted on Clearwater Beach, and they wouldn't even take the damn report. So how in the world would a police officer even take the time to take a report from someone who's saying this man yelled at me?
Probably the same way that Jane Doe filed her report. You walk into a precinct and say, I want to file a police report. Old boy sitting at the desk takes half a page of notes, and he says, guy walks in, complains he got his feeling hurt, no further action required. He assigns it a number, puts it in a file.
Interesting.
As we say in the South, whoop-de-doo.
Well, I guess it just pisses me off even more that the officers who I called to come to the place where a Scientologist boyfriend had just punched me in the head several times, they didn't even take that report. They didn't even say, further action. They didn't take anything.
Just because somebody calls the police and says, I want to file a police report, doesn't mean the officer writes anything down. The officer, okay, anything else? Thank you. And they move on.
Well, yeah, I mean, 4 officers showed up and interviewed me on camera with their body camera footage, body cams running, but just refuse to take a report. Anyway, I'll leave it alone. It just really kind of pisses me off, to be honest. This was a couple years ago. All right, Matt Elliott says, "Hey, Aaron, any update on the defense material leak and your lawyer friend Zach Morgan's thoughts on it?" Yes, this was something else we were going to discuss. So, what are your? Do you know what we're talking about here? Right, the evidence.
I do.
So, the redacted discovery file that the DA turned over to the defense in this case was leaked to Vicky Podboreski, Scientology's attorney. Now, the defense's argument was there was no order of protection. And the judge basically said, whoa, 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 whoa. You guys, the defense, asked for an order of protection to keep the Jane Does from talking to the press if they wanted to. I told you I wasn't issuing an order of protection. However, I did order you not to share discovery with anyone in the civil case. You were specifically ordered that. So again, it's one of those things where I had to ask myself, why is the defense making arguments to the judge that they know are not valid arguments? But anyway, can you help us understand the significance? Sure. What would it mean? What's the significance of this leak if it's proven? Yep. Well, it's proven because we know it occurred.
Well,
we just don't know who did it yet. How does this impact anything?
So, for one, the discovery rules in criminal cases are different than the discovery rules in civil cases. Generally speaking, in criminal cases, the DA, the prosecution is required to give me everything that they have, whether they're going to use it or not, and whether it's inculpatory or exculpatory, excluding certain security-related things like investigative techniques, the identity of confidential informants, the identity of undercover officers, things like that are public safety concerns. You don't have to disclose that. You can say, we're going to call a CI, or this report is based on information from a CI. And at trial, they can call the confidential informant, but they'll put them behind a screen or, black their face, stuff like that. Same thing with undercovers. In a civil case, if I don't specifically ask for it, you don't have to turn it over. And I'm sure you've seen a civil discovery request. I need all documents, books, papers, writings, emails, faxes, pager data from the 90s, cassette tapes, VHS, DVD, any medium of any kind, whether virtual or physical, that contains anything with the following words. If I just say, give me everything that you have, that's too broad. If I say, send me all of your emails, but you were smart and wrote everything down and mailed it snail mail, I didn't ask for your snail mail, I don't get it. Right. So the rules of civil discovery are different. But more importantly, there was a court order that you can't do that.
Right.
Violating a court order is violating a law. A court order has the force and effect of law to the parties bound by it.
So what are the penalties for violating a court order for an attorney? Especially, it seems like a pretty important court order.
So you could be, so for one, it would be certainly civil contempt. So the maximum punishment would be paying a fine. Criminal contempt, possibly, in which the maximum sentence would be incarceration in the county jail, generally not to exceed 1 year, and a fine not to exceed $500,000, whatever it is. 500 or 1,000, not $500,000. Sorry, some small arbitrary amount of money, or not to exceed a year in the county jail. It would be sanctions by the court, monetary sanctions, or in this, it's a little different in this case because there's no discovery going on, or an adverse jury instruction. It would also certainly be a referral to the attorney disciplinary committee, whatever that looks like in the state of California. In Oklahoma, it's called the Oklahoma Bar Association's Ethics Council. Would be a referral to the Ethics Council for violation of the various duties and obligations attorneys have by virtue of practicing law. So there's a laundry list of things that these folks could be exposing themselves to, both criminal, financial, as well as professional through some sort of sanction through the legal governance folks.
So some of those are worse than others, but it sounds, generally speaking, slaps on the wrist. No one's going to be put out of business over this.
No, but it could be a fine. And that's, if the judge says, I'm going to assess you a fine, the judge will likely have an evidentiary hearing that says, bring your firm's financial records. Right. I want to hit you with enough fine that it materially affects you, but not so much it puts you out of business. And that's generally up to the judge. It could be $150. It could be $50,000. It's at the discretion of the judge. And it depends on how mad the judge is. And in this case, Judge Olmedo's pretty upset about it.
Amazing. Tom Mesereau seems to be at the top of the list of suspects for having leaked this information. No one knows for sure, but there's sort of been a consensus he's the most likely culprit. Is the only attorney that will get in trouble the one who leaked it, or would Vicky Podboreski potentially get in trouble for accepting it and being in receipt of it?
So if Vicky knew about the court order,
She'd have to. She'd have to. She followed.
So if Vicky knew about the court order and received the material, she has an obligation, a legal obligation, to go to the judge and say, Judge, I received this. I didn't request it. I didn't want it. I did not solicit it. It showed up at my doorstep or in my email inbox. I'm giving it to the court. I've deleted my copies, and I am disclosing to the court that this exists. She didn't do those things.
It would be impossible for the court to believe she didn't know, considering she's been present. She's been present. She's been following this trial so closely. She's literally showed up in person to watch the proceedings. Okay. All right. Warabi, hit that like button. Do it for our awesome lawyer friend, Zach. Yes. Supreme Rula. Any level court dress turns client damaging in U.S. I have no idea. What does that mean? Am I reading it wrong? Any level court dress turns client damaging in U.S. Sorry, I don't get it.
So, so based on the fact that they paid you in the British pound, that's the L. The British have what's called court dress, where attorneys have to put on the morning coats and the fancy pants and the weird wig. And we don't have that in the United States. Men have to wear suit and tie or jacket and tie, and women have to wear either dresses or suits to court. So we don't have the traditional court dress in the U.S. I think that's what they're referring to, because in the British style of the legal system, they still wear the wigs. Even the women have to wear these ridiculous horsehair wigs, but we don't do that in the United States. So court dress is a specific set of apparel in the UK, but we don't have it here.
Yeah. Okay. Midwest girl. Hey, Aaron, when you get your separate YouTube channel, you should have my attorney friend Zach Morgan merch in your merch store. Well, that wouldn't be very nice, because that merch should be in my attorney friend Zach Morgan's merch store. But I have no plan of starting a separate YouTube channel. It took me long enough to build up the subscriber base for this one. I'm not like Mr. Oh, you got to go?
Yeah, we need to wrap it up here in the next few minutes.
Okay, let's do it. Let's do it. Let me see. Okay, hang tight here. All right. So
I want to make sure we get as many of these super chats as we can, because I know we've got a bunch of folks wanting to inquire.
Yeah. Okay. Hold on. So we'll keep it brief. Okay. Drugging someone to have sex with them is forcible rape. Aaron had to delete a lot of my text because I ran out of character space. So in the state of California, it's considered rape. It's not considered force, because the method used was the drug, and theoretically they're unconscious.
Yeah.
In the state of California, they make a distinction. What can I say? Don't blame me. I'm just the non-qualified messenger. Okay, Diane B. Zach, where's channel LawTube and SPTV would welcome? You guys, what's with the fat fingers on the keyboard today? Come on. All right. Andre, can the fact that Scientology obtained discovery materials in the criminal trial be used as evidence against them in the civil trial, showing intimidation efforts, obstruction of justice? It's a very interesting question.
Yeah. So, Andre, the short answer is anything is possible, but I would need a lot more factual information to give you a solid answer. I'm sorry. I wish I could answer it better.
Yeah. Cassie Isaac, we need some Zach merch. RV at the beach. Great analysis as always, Zach. Longtime Poke fan here. Let's see the shirt.
Loyal and true.
Annie Kitts, the Zach pack. Goldie approved. Love it. Okay, good. Last few here. Denver Stevo, excited to subscribe to my attorney friend Zach Morgan. On an unrelated note for both of you. Favorite song and movie, current and of all time. P.S. Hi, Osa, you smell like poo. All right. Do you have a favorite song in a movie?
Favorite song. Well, my favorite song is probably I Want to Know What Love Is by Foreigner. Just, you can't have a bad day when you listen to that. And I'm going to withhold my favorite movie for reasons that would become apparent once Aaron knows what it is, but we'll move
on. I'd say favorite song, Disturbed rendition of Sounds of Silence. And favorite movie, I'm going Shawshank Redemption on that. That's,
okay.
Yeah. And my favorites tend to always be my favorites, not current and all time. Okay, we're almost done here. Shannon H, outstanding coverage. Ron, emotionally taxing, so take good care of yourself. Thank you very much. Ryan, if it's proven that the signatories on the letter were listed without their consent, could the whole letter get tossed, and can there be legal ramifications against anyone who drafted or paid for it? I don't think it's a matter of getting the letter tossed. The letter's not evidence. It's just
letter's not evidence.
It's just bitching about the judge. So, but there's much more to come. We'll do a whole dedicated video on that letter later.
Yeah.
Okay. Jermaine Dawn, congrats to Zach for joining the legal education community on YouTube. I've loved that community ever since I was an IT tech at OSCN and wanted to learn.
So OSCN is the Oklahoma State Courts Network. That's the online court database in Oklahoma. So,
oh, very cool. Here's Shelly Knapp says, Aaron, how did you and Zach meet, become friends? Zach, how did you and ASL meet, become friends? It's because he was watching some of the videos that I was doing about the Danny Masterson case, and he emailed me saying, hey, I'm an attorney. I could share some opinions with you on this if you'd like. And it took me quite a while to get back to you, actually.
But we got there.
We got there. Okay, super close to the end here. Okay, Aaron, you earned your keep today. I now know who to call if the FAA ever comes after my pilot certificate. Before, I was just going to rely on threatening to release Xenu from prison. There we go. All right, guys. Well, we are a bit short on time today. Actually, I mean, we've done 35 minutes. My God, time flies. All right. Well, I hope this has been fun and educational and inspirational and all that good stuff. Thank you guys for watching. Thanks to everyone who watches until the very end. And we'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not,